Good afternoon to everybody, to the candidate, Mr. Radutnyi. The advisory group of experts continues with interviewing candidates for the position of a judge of the Constitutional Court of Ukraine. Our next candidate is Mr. Oleksandr Radutnyi. He is participating in this competition under the quota of the President of Ukraine. Mr. Radutnyi is an associate professor at the Department of Criminal Law of the Yaroslav Mudry National Law University. We are ready to begin. So I will pass the floor first to the Secretary General of the Advisory Group of Experts, Mr. Yaroslav Romanuk, who will explain the agenda of this interview, the way how the interview should be conducted, and to moderate it. So, Yaroslav, please, the floor is yours.
Дякую, пане голово.
Thank you, dear Mr. Chairman. Greetings, Oleksandr. Greetings to all who's watching our broadcast, and I would like to greet you with the Day of the Ukrainian Statehood. As it was already mentioned by Mr. Chairman, today all 6 members of AGE present at the interview, and that is Chair of AGE Alex Zalar, AGE members Ms. Maureen O'Connor, Hanna Sukhotska, Oksana Vasilchenko, AGE member Vasil Shakun, and myself, Secretary of AGE Yaroslav Romanuk. Also present during the interview are 5 deputy members of AGE, Mr. Richard Barrett, Marek Zubik, Volodymyr Kuzmenko, and Vitaly Makhinchuk. Also, distantly present, Mr. Thomas Griffith. Oleksandr, you have already participated in the competition for the position of Judge of the Constitutional Court of Ukraine. You have been interviewed already and assessed by the group of experts, but I still want to explain to you the rules of this interview. So, the interview is one of the mandatory stages for evaluating the criterion of high moral qualities of the candidates. The advisory group conducts interviews with candidates in accordance with Article 7 of the methodology, including to clarify and dispel any doubts regarding their high moral qualities. In fact, this is in your interest. You're given the opportunity to dispel the information about you, which in your idea is untruthful, and also try to dispel any doubts regarding your high moral qualities that the advisory group has. During the processing of materials regarding you, Mr. Oleksandr, the AGE sent you questions for written explanations, so you had the opportunity to prepare and submit responses, and we are grateful for the communication with the advisory group of experts. I also draw attention to the fact that according to Part 8 of Article 7 of the methodology, you, Oleksandr, cannot provide information, documents, or other materials during this interview if the advisory group requested them earlier and you somehow did not provide them within the specified period, or if you could have provided them but you decided to provide it today on your own initiative. However, we may make an exception if there are justified reason. I also want to inform that the interview is being recorded and streamed live on AGE resources and on the website of the Constitutional Court of Ukraine. Therefore, I urge AGE members and you to be mindful of limiting the use of sensitive data and restricted access information during the live broadcast. If there is such a need to speak or to tell such information, we will suspend the live broadcast in order not to disclose this information. Dear Oleksandr Eduardovich, I also want to draw your attention that the interview duration is approximately 1 hour and the time limit for answering questions is up to 3 minutes. I kindly request you to answer in the laconic way, to be brief and to the point. At the end of the interview, you will be given the opportunity to make a brief closing statement of up to 5 minutes. Part of the members of the advisor group are English speaking, so if your level of English is insufficient to understand it, you have the chance to use the headset for simultaneous interpretation. Blue lights on the headset means that the translation is on from English to Ukrainian and vice versa. And right now we are ready to begin the interview, and I will be the one to begin, and I have a few questions for you, Oleksandr. So you have already participated in the competition under the quota of the Verkhovna Rada of Ukraine. You have participated in the competition and you got the corresponding decision of the advisory group of experts. So tell me, please, do you confirm the accuracy and reliability of all the information you provided with the competition for the position of Judge of the Constitutional Court of Ukraine under the quota of the Verkhovna Rada of Ukraine? All questions that were all answers that were provided by me before, they were objective, transparent, and honest, but they require clarification. I see. So, because of this, I have another question. Would you like to inform some additional information or to add your answers to the questions that you were asked at the previous competition? Well, first of all, this competition is a separate one or independent. Oleksandr, we are not only going to ask you the questions that we didn't ask before, but also those that you already had the chance to answer. So are you willing to add your previous answers? Yes, of course, I am willing to. Okay, to clarify, to extend, yes. I see. So, as for your candidate, the advisory group of experts has already made the decision, and you were identified as the one who is not in line with the high moral qualities to take the position. According to the information that we have, you are not familiar with the final wording of this decision and the motives why the advisory group of experts made that decision. Do you have information about the motives of the advisory group of experts, in accordance with the results of the previous competition, has recognized you as the one who's not in line with these qualities? I can only guess, judging by the questions that I was asked, but on the website where there is the official information about the candidates who were recognized, the ones who are compliant with the criteria or incompliant, there are files, there is information, detailed information about those candidates who were recognized as compliant. And then there are also the decision on those who were not. And they have specified the names, but a more detailed explanation, like on the reasons, I wasn't informed me. Why didn't you try to get that information when preparing for the new competition, in order to be able to debunk or refute the grounds that served as the basis for recognizing you as the one who's not in line with the high quality moral qualities? I am curious about all the information that refers to me in the framework of this competition, so that's why during the previous competition and this competition, I studied the dossier. And as for your question, I used the official resource, hoping that there would be published information there. And I thought that if it wasn't published, then maybe because of technical reasons or because of being busy, reasons, this is only due to the requirements of the law. It does not envisage the possibility without publicating it without the agreement of the candidate himself. And by the way, you said that you studied the dossier. After you read it, additional information was sent, and we are going to talk about it today. Do you understand which information I'm talking about? No, no, I'm not familiar with it. Okay, we will give you a chance to familiarize with it. And now I would like to continue the interview with you, and I will ask my colleague Maureen O'Connor to continue.
Thank you very much. Good afternoon.
Good afternoon.
Thank you. I'm going to ask you maybe about 10 questions, and they're going to flow, I think, one related to the other. So I'm going to start by asking you about your declaration from 2023. In that, you indicated that you received a salary from the Mudry National Law University, and that's your employer. Is that correct?
Yes.
And the amount that you identified was approximately 200,000 hryvnia. Is that an accurate number?
Ви назвали приблизну інформацію.
You said the approximate information, and I agree with it.
The reason I ask you that is that that information was given in October, and I'm presuming that you had additional months on the year to teach for the year 2023. And then if you compare that amount with the previous year's earnings that have been reported, it's I think the previous year I'm looking at 356,000 hryvnia for income.
Yes.
Okay, so you reported 200,000, and the year before you had about 350,000. Did you not think that there was going to be a discrepancy for our purposes by not doing the entire year?
It did not look as a discrepancy since the salary got lower at that period of time, and the employees are transferred for 0.85 of the rate. So of course the salary will also reduce as compared to the previous years. Apart from that, the only state register of declarations envisages the possibility to use as the base the previous declaration as the foundation. The previous declaration also included the salary per 2023. This information I obtained from the state register of state military insurance, and this information did not pose any doubt for me. Moreover, it's no secret for everyone that I participated in the previous competition, and this information, there were no remarks on account of this information previous time. That's why I had no grounds to doubt this amount. In fact,
I understand what you're saying, but so I'm clear about one point that you made here is that you were earning in 2023 considerably less money because your salary had been cut at the university, the law school. Is that what you're telling me?
it's only part of the answer. It's only part of the answer, and the second part lies in me having used the previous declaration for 2023, where this amount was indicated, and there was no remarks, not from me, not from experts. Nobody paid attention that the date of, I will tell you exactly. The date doesn't include the full salary per 2023, but since a lot more questions that require additional attention. The question that has already been answered, I didn't consider. So I just took the previous declaration, used it as the basis, as the foundation, and just moved on. But
You agree that's not a correct amount.
В реальності
in reality, the amount, because of a few months, is a bit higher than the specified. But at the same time, I'm asking for you to draw the attention that both amounts, the one that was specified in the previous year and the one that's a bit higher because of 2 months, they all were obtained from the same employer. That is the legal income, and all taxes and fees, mandatory payments were paid. So this, I admit that this is a mistake, and this mistake has been taken into consideration. It will be corrected or fixed, but I'm asking to pay attention that this mistake does not testify about the lack of integrity.
Thank you. In 2023, your wife, according to our information, received social payments amounting to 6,000 hryvnia from the Labor and Social Protection Administration, and that was not mentioned as income in the declaration in 2023.
це вже питання.
Is that a question?
I'm asking you, why wasn't it recognized or declared?
З цього питання
It's very easy to make a mistake. This amount, 6,000 hryvnias, is connected to the assistance the person, the temporarily displaced person receives because of the armed aggression. The source of such assistance can be both the internal and external organizations. Why is it easy to make a mistake? Because in my opinion it would be easier to include into the declaration the external international assistance and not the internal, because it's still government controlled. And I am familiar with the explanations of the NAZK that I referred to. These were the explanations as of 2023, November the 13th. But there it says that the international aid must not be included, but the internal, and that's very not clear to me. But these are the rules of the game. Okay, we'll do that. I made a mistake. Yes, I admit it. Does this mistake also testify as lack of integrity? I would ask not to include it, because this is a legal assistance. It does not influence the payments or taxes or any other fees. These are just the rules of the game. What are we going to include into the declaration? What we shouldn't. Somehow we shouldn't include the international assistance, but the internal assistance, the national assistance.
Right, thank you. In 2018, your wife, she acquired a Mitsubishi automobile. Okay, you say it. Pajero, is that correct?
ви кажете 18,
2018? If you're saying 2018, that it's incorrect.
ви
So are you saying that my wife purchased this car in 2018? This is not correct. She sold it in 2018.
All right, so she owned it, she sold it in 2018, and that was a 2007 vehicle? The year of its manufacture was 2007?
Yes.
All right, what was the amount that was received for the car?
We are talking about the declaration for 2018. That was my first declaration in my lifetime, and that was the worst declaration. There, unfortunately, I made all the mistakes that I could make. And these mistakes concerned not only this movable property, it was also about real estate property, and I got criticism about that last time and even the time before that. But this declaration, in my opinion, cannot be considered as the declaration of the person authorized to fulfill functions of the state or local self-governance due to the following reasons. Firstly, because of the absence of such person. I was not and I have not become such person. Secondly, it was submitted exclusively within the framework of the competition. Thirdly, that competition did not take place due to the reasons because organizers cancelled the competition. In my opinion, these three circumstances actually result in the summary regarding that declaration. It should not exist. It contains lots of mistakes, but that declaration should not exist. Therefore, I've addressed the NACP with request to delete this declaration from the website. I got the response that they cannot start the countdown of the 5-year term since the moment I stopped fulfilling functions of the state or local self-governance, because I never started fulfilling those functions. So they cannot start countdown. And this declaration will be forever at the website. But in response to your question about this and other mistakes from that declaration, I would like to emphasize again that it has no social relevance. Because social relevance of the declaration, in my opinion, consists in the following. The person should report to the society every year, and in dynamics, then it is possible to track changes in the lifestyle of the person. And it has no legal meaning as well, because it was submitted within the framework of one competition which did not take place. This person, that is me, I have not acquired those functions, and that's it. That can be a full stop.
So there's irregularities in several of the declarations over the years that we have noticed, and you agree with that. They were mistakes, 2023, 2018, and is it your position that there is no way that you can amend those declarations? You cannot give additional information to have that appended to your declaration?
I've missed one more important aspect. With respect to declaration for 2018, I submitted all title documents attached to that declaration. So, on the one hand, we see mistakes. On the other hand, only within the framework of one competition and not in any other things. And I submitted title documents where you can see the amounts. With respect to...
Stop you right there. Did you do that for your wife's car, the sale of your wife's car? Because you told me that it was sold and it was not declared, correct? The amount was not declared in 2018?
I would like to explain again that we are talking not about the declaration of the person authorized to fulfill functions of the state, also local self-governance, but the potential candidate of the competition. In my opinion, it is very important. Yes, it was not declared. This information was omitted. I missed it. Why? If you allow, I can explain why I missed. I have 2 minutes left to give my answer. 2018. Imagine. Recollect the year when you did not know that you would be experts of the AGE. A year before you became members of the AGE. Were you preparing to become members of the AGE? Probably no. In 2018, I did not participate in any competition where submission of the declaration was required, and I was not the entity required to submit declarations. So in 2018, I could not forecast that in 2019 I would take a decision and I would have to consider the previous year, and then I had to collect all the documents, but they were not collected. And with respect to this Pajero vehicle, it was sold. How does the sale take place? A new owner gets the certificate on the right of ownership, and that's the only document that the new owner requires. The old owner has nothing left because he gets rid of his property. The agreement that is concluded in certification bodies is not required by anyone, neither by a new owner who has a legal certificate, nor by the old owner. Why? Now you might have a question about taxation. No, the issue of taxation does not emerge, because as of the moment of registration, all taxes, duties are paid as of the moment of registration, and that public authority controls this issue. So in 2018, this document, which I did not need, maybe it's somewhere still, I cannot establish where. In 2019, I had this new need to specify everything. I take all the documents that I had, and it did not help me to avoid mistakes with respect to the real estate objects. And there is the position with respect to which I have no documents.
Let me clarify something for my benefit. How often are you required to file a declaration?
Жодного року.
I do not need to do that any year. I do not need to do that besides those instances when I take part in competitions.
Only trigger for a declaration where you're telling your income, your wife's income, income from the sale of a property, whether it be an automobile, a real estate, etc. That's only recorded. It comes to the attention of, in the form of a declaration, when you apply for a competition. Is that how that works?
Yes, absolutely right. Right now, not only experts of the EGE listen to my explanations, but many other viewers as well. So that my answers would be clear, I have to say that these declarations are submitted not by all citizens of Ukraine. There is a small group of people, these are officials, let's call them like that. These are judges, prosecutors, public officials of a high level. Only they have to do that. I've never been a member of this group, so that's why I'm on the side where the other citizens are located, and these citizens do not need to submit the declarations. So in response to your question, yes, that's the only instance, only trigger when I need to submit a declaration. And therefore, I have years when I did not submit the declaration, and no one is commenting or criticizing or doubting that.
So the money that was acquired when the automobile was sold, 300,000 hryvnia, is what the figure that I have from Nabu is 300,000. Would that be considered income?
В мене
You have this information. If this is new information that you've just mentioned, that you have been received in this year, I do not have this information. If I say now this amount, I'd agree to that, but I don't have a document for 2018. How can I agree to this figure? My answer would be the following. The amount was not specified in the declaration for 2018 because the document did not exist. The document specified the amount, so I do not know this amount. So I cannot agree to your suggestion that the amount was 300,000 hryvnias.
No reason, though, to think it was something other than that. You're saying you don't know.
Can you please specify the question? What is the information that you are talking about? What information are we discussing right now that you have received from the NABU? For which year? So that I could answer your question.
Automobile was sold in 2018, and that's the year I'm speaking of.
Так.
Yes.
You're aware that you were entitled to come in and take a look at your file with the advisory group of experts before you came in here today to interview. Are you not?
Я про це вже
I informed at the very beginning about that. I've looked through the materials. And just now, you informed me, and I did that on July 9. On July 8, I received information that today my interview was scheduled. And with the email, I've expressed a request to look through the materials. In response, I got the consent, and on July 9, I looked through the materials. In that dossier, this information was not included, so it is very difficult for me to comment on what you are asking right now. If that is new information, let me please look through it. As of July 9, this information was not in my dossier.
Thank you. All right, I'm going to ask you now about the acquisition of a Ford Escape, a 2020 Ford Escape, and that was acquired by you, is that correct?
A clarification, my family acquired this vehicle. My family consisting of the husband and wife. That's required by the current legislation. When the owner is one of the spouses, then the other spouse is also the owner of the vehicle.
All right, thank you for that clarification. So on June 4th, 2022, you and your wife acquired the Ford Escape at a U.S. auction. Is that part correct so far?
так.
Yes.
Circumstances.
Уточнення.
A clarification, not on June 4. June 4, that is the date of registration of this vehicle on the territory of Ukraine. I would not want right now, because I made many mistakes, so I don't want to make any new mistakes based on this information.
The date.
Яку ви мені пропонуєте? Так, я знаю.
Yes, I know the date. 1 second, I will use, if you allow, my notes. And if I'm not mistaken, that was October 27 or November, I will check it, of 2021. That is the date when the auction took place on the territory of the US. The vehicle was brought into Ukraine not as a vehicle, but as a damaged movable property. After that, for 6 months, it was repaired. Then it passed through certification and it became the vehicle again. And 6 months later, on June 4 of 2022, I got the document for the vehicle as for the vehicle.
Okay. Then on March 7th of 2024, at the interview with your first interview, you informed that the source of the money that used to purchase the Ford Escape, the 2020 Ford Escape, at auction came from the transfer of $7,800 US dollars, and that source was your salary in 2021. That's the information you gave us, and that's the information that you stand by? Is that correct?
That's partially information. That's partial information because I also informed my salary for several years. And my response was extended because all the expenses on this vehicle included not only the purchase of the vehicle, but also its repairs.
So, again, you're telling me that the source of the payment was money that you had saved and then used for this out of your salary. Is that correct?
Partially, yes.
Where else did the money come from if not your salary?
Just now, in the question, you've recollected my answer, dated March 7, but it consisted in the following. It included salary. What was I governed by? I will explain. The price of the vehicle is 255,000 hryvnias. That is the amount that is relevant to 7,800 US dollars. That's the amount that was specified by the public body based on the official currency exchange rate. So, the amount of 255,000 hryvnias. Okay, 2021. Salary for 2021. 418,000 hryvnias. Okay, let's go further. Was this argument enough as the key argument? In my opinion, yes. Why? Here we have math. According to one second, please. Here it is. Why, in my opinion, was this argument enough? If you have enough arguments, you don't have to look for additional arguments. And here I will explain why it was enough. My salary was 418,000. The price of the vehicle was 255,000. According to the law of Ukraine on the state budget for 2021, the subsistence minimum for an able-bodied person amounted to 2,198 hryvnias. For year, it amounts to 26,268 hryvnias. For two persons, including me and my wife, that was 52,536 hryvnias. And we have, after that, 366,000 hryvnias remaining to buy the vehicle that cost 255,000 hryvnias. This position coincides with the official perspective of our government, of our parliament, no matter how strange it might look. And in my opinion, that is quite enough. However, I understand that maybe that was not enough. So then, in this case, as specified in our correspondence, we should recollect another amount, that is additional argument in order to refute any doubts. And what is this amount? That is amount of 616,000 hryvnias. So, 418,000 plus 616,000, that is for the purchase of the vehicle that cost 255,000. Everything is transparent, no doubts about that. Oleksandr Eduardovich, for you to understand why we have this question, because you use the figure of 418,000 per year, but the car was bought not at the end of the year. It was bought, as you said, in October or in November. And as of the moment of the transfer of these funds for this vehicle, you had another amount that was another amount, and that is even without taking into account that until the moment of transfer of funds, you had to leave something. You had to use money for life, and you also went on a vacation with your wife to Turkey, and you also needed money for that. So that's why we have these questions. You are wrong.
You are wrong. Please explain. The car was purchased at the end of the year, not in the beginning of 2021, when the salary was 0 hryvnias, but at the end, when the amount is closer to 418,000, that's one. And second source is 616,000 hryvnias.
Source.
Давайте.
That was not disclosed to us previously, was it?
Ця інформація
This information wasn't only disclosed, but it did not get into the declaration for 2020 because I did not submit that declaration. I did not participate in any competition, and I was not the subject for declaring, and I'm not that subject now either. That's why this information just was somewhere there. I only needed it when it became necessary. So when I saw that the amount 418,000 is not convincing, but the amount 418,000 plus 616,000, it looks convincing, right? Right. This is the explanation.
Let us know of the $616,000 from the sale of the property. That's fairly recent information that's come to us, is that correct?
так звіт.
Yes. This is the information that I have additionally informed in the framework of this competition in order to enhance my argumentation and explanation of transparency of the sources for purchase of this vehicle.
You seem to, the feeling I'm getting from you is that we shouldn't be asking these questions. If you have $418,000, give or take, coming in, you buy a car for $255,000, that leaves $153,000 hryvnias for two adults to maintain a lifestyle, vacation, etc. You can understand why we would be skeptical in reviewing that. So then additional information is asked of you, not volunteered, but asked of you, and you say, oh, I forgot, $616,000 came my way, our way, in 2020, and we've been living on that. Is that a fair assessment?
Я ще раз повторю.
I repeat myself again that this information was provided by me in order to strengthen the argumentation and for transparency. There are no sources that are not transparent. There is income for 2020. There's income for 2021. The car was purchased at the end of 2021, and the amount is completely it shows that it's in line with it.
Moving on then to some real estate. In December of 2017, your wife acquired an apartment in the city of Kharkiv. And what was the cost of the apartment acquisition that your wife paid?
On December 20th, 2017, the apartment with total area, and please pay attention, the total area of 19 square meters was purchased with 292,000 hryvnias. 292 and 783,000 hryvnias.
That money, what's its origin?
З джерелом походження
So I have provided this information on the source in the emails. For those persons who are watching and who do not know the background of this mailing, I would like to provide the explanations, and they are the following. My wife, her son, and her mother, at the end of 90s and the beginning of 2000, they lived in the city of Ismail, and there they have privatized, the three of them, one apartment, and it is indicated in all documents. After the death of the mother, my wife has inherited part, her share, And so the two of them, my wife and her son, they are the owners of this apartment. And they alienate it to the new owner. And this is the source of origin of purchase of the apartment that we are discussing, but in the new city, the city of Kharkiv. Tell us, please, the last name of your wife and and the son. Isn't it a sensitive information? Okay.
Який спосіб відчуження?
What was the way of alienation? Was it the purchase-sale agreement? Well, as for this way, we had also communication with an advisory group of experts, and it seems to me that I managed to convince you that the way that we have chosen, I mean, for example, donation or the gift, it falls under the general definition of the alienation, and this is very important. So during the notary agreement, the notary fees and other payments irrelevantly. No, this is not the point. We are not arguing with you on this part that this was a gift. The question has emerged why the sources of origin of the money, because you said that the sources is the alienation of this apartment in Ismail that belonged to your wife and son. So if this was a donation, then it does not presuppose getting some payment in return. This must be free of charge. So what happened? Was it a gift or was it the purchase sale? This was alienation of the apartment with funds, but we have chosen the form of gift. I have explained the form of gift, but in fact this is alienation. Yes, I explained that for the one who's selling or who's alienating this apartment, this is not a matter of principle. It can be a matter of principle for the one who is buying, who's purchasing this apartment. Like, for example, something that has been obtained as a gift or inherited is not the owner in ownership of the couple. And maybe the notary has advised us, because I have described this in the emails, that there were big issues with registration of this property. And what about taxation of the funds? No, it's all transparent. The same conditions for purchase sale agreement and alienation. And I would like to put emphasis on this for those who are watching us, that taxation and registration of this agreement are the same, irrelevant from the form of purchase and sale or donation. Why? Because in the legislation, and the notaries are using this, it is covered by the general notion of alienation. Microphone, please.
A gift is the same as a sale for the purposes of the definition of alienation. No?
Ні.
No. Oleksandr, so when you're giving the gift, you have to pay taxes in accordance with the evaluation independent evaluator conducts. And if it's the purchase sale agreement, it's not only depending upon this evaluation, but also depending upon the price that the parties agreed to. And these can be different things between the evaluator's result and the conditions on which they agreed to alienate it. Isn't it right? I think not. Okay. So let's repeat again. Do we understand you correct? So there was the gift agreement, but actually this was the purchase sale agreement. I need 2-3 minutes to give you the explanation, please. Such cases are multiple ones. When the factual sale or alienation takes place, but under other forms. And we have just considered the form of gift. But there is one more option. For example, when the transport vehicle gets new owner via registration of the powers of attorney. And I have explained this already, but I will explain it again to those who are watching us. As a result of this, the new owner gets the power of attorney, the general power of attorney, the certificate for this transport vehicle, and the vehicle itself. That's all. It's very risky. Yes, it's risky for him, for the one who purchased this vehicle. But this is the same widespread transaction, just like the one that we are discussing now. So there's nothing. Yes, Alexander, there are such cases, but it's about us not having the chance to make sure which factual amount did you get from alienation of this apartment in accordance with the purchase and sale agreement. And of course, we have grounds to have well-grounded doubts. We have no possibility to, have any proof because you cannot debunk the doubts that we have. Only because you have selected this form of alienation. Give me 3 more minutes and I can debunk your doubts. This property.
Real estate, not a car. So if you're going to give us some examples and explanation, let's have it pertain to real estate.
Вони
They will refer not only to real estate, but the specific one that we're discussing. Please give me 3 minutes. So, the owners of this property, of this real estate, is my wife and her son. They have the right to realize this, and they are doing it. An important moment I want to draw your attention to is that me as a man, as a husband of this wife, I have no rights for this real estate. Why? Because it was obtained first as the result of privatization, second, inherited of the share. And what does it mean for me? It means that I should not interfere into these matters. I am not even supposed to pretend that I am curious or that I want this real estate property. That's why when you're asking me which form have they selected, the one that we see. Why have they selected this form? I do not know. That's the question for the notary and for the participants of this agreement. How much money did they get for this? That's the correct question that I should not interfere with. I know another thing. I know that as the result, this amount was used to purchase a very small apartment in Kharkiv. And there is the document testifying this to confirm this. And that's already of my concern. Thank you. Mr. Alexander Eduardovich, you somehow silenced this information before, and you didn't provide these documents for us to get familiar with this, and you had this agreement. We got this agreement of purchase sale from the Minister of Justice where it says that the parties of the agreement of the gift, they assess the property in the amount of 93,000 hryvnias, 310 hryvnias. But we speak about the apartment purchased with 292,783 hryvnias. So again, this is a discrepancy. And you deprive us of the possibility to make sure to find out the real amount that was obtained because there's no document confirming it. The settlement, as far as I understand, was done in cash, right? Without bank, without the bank account, without the bank transfer. I have the answer. Please, I'll try to convince you. The answer is the following. This document you refer to, I do not have that document. I do not have it because I did not participate in this deal, and I have just explained who was the owners and who got the income. By the way, the income obtained from this real estate that is not in the volume of the real estate of the marital status. Second, this gift agreement. I asked my wife and told her that I needed to report in the communication of the advisory group, and I requested these documents from her, and I was explaining myself, and she said she didn't have it. And then I asked her what was the amount that it was sold at, and she said that if there was no document, she couldn't tell me this. But the main question you asked refers, allow me to articulate it. Where did you take money to buy apartment in Kharkiv, and what was the amount, and was it sufficient? The answer: the money came from here. Then which were the funds? Those that in fact were given by the buyer to two salespeople, and this amount was actually put on the bank account, because all of this took place in Ismail and the woman had to go to Kharkiv. So not to have the criminogenic situation, they were in the bank account. So all transparent, and then they were used for the purchase. So let's do this again. If I fail to convince you,
You got about 93,000 for the sale, gift, whatever, of the property that your wife and her son owned. That's already been established. You purchased this new place for $293,000. Where did the not dollars, I'm sorry, hryvnia. Where did the 200,000 come from in order to purchase this apartment?
Відповідь тільки
I have just told you the answer, but I can repeat myself. The amount for the purchase of the apartment in Kharkiv was taken from this agreement. In this agreement, it says that it was a gift. In fact, it was purchase-sale agreement.
In that document. That's evidence of a transfer. For how much money?
в цьому так. Це я не яку
Of which transfer? You just provided me the information you have obtained after I learned the dossier, the document about gift, right? But we did not find out now, right from the start of our emailing, in 3 rounds, in 5 letters, I was explaining this, that this agreement indeed is the purchase-sale agreement, that the one that you have just provided. And for this, we got the money was obtained. This is purchase-sale agreement. And then there was again purchase and sale. This was the apartment of that was bigger, and this apartment was smaller. For the funds that was obtained, we could only purchase this small apartment. That's how I can explain it.
Олександре Едуардовичу.
Mr. Oleksandr Eduardovich, I also have a few questions for you. As of 1998, you were a lawyer, yes. In order to provide highly professional, good quality provision of the services to the citizens or private persons, the law on the bar and legal practice obliges the lawyers to undergo the regular upskilling or advanced training of lawyers of Ukraine in the and according to the information provided by the National Association of the Bar of Ukraine, you did not do this in 2019, 2020, 2021, 2022, and 2023. Why not? The information obtained by the advisory group of experts from the Ukrainian Bar Association is only partly true. It indicates that the National Bar Association does not have the information or lacks information, and this is true. Whether or not I have increased my qualification or did the upskilling, it's about the it's about advanced training in as a regulation on it. And yes, the law requires to undergo the advanced training, but it doesn't require visiting the events that are held by the National Bar Association.
Instead, I have provided, and I hope that all members of the AG have had the possibility to look through that. But in order to show that to the public and to viewers, I have provided numerous certificates and documents stating that I have always annually improved and advanced my training. In particular, if we look at the criteria used by the National Bar Association, then advanced training equates to participation in events as the lecturer. Not as a passive listener, but as the lecturer. And I participated in such events as the lecturer. The entire list is given in my answers. Then, there are additional events under the auspices of the National Bar Association, in particular including conferences and other academic events. And I also participated in them, not as the listener, but as the speaker. And in our correspondence, I've provided examples of all of those events. For example, the conference titled The Bar of Ukraine, Current Condition and Future Development. That was the conference held in 2022. Oleksandr, we know about that. You've provided this information. It is available in your dossier. But again, in July of 2021, the Bar Association has adopted a procedure on advanced training for attorneys, which specifies requirements regarding improvement of the professional level of the attorney. That procedure was adopted in order to comply with the law of Ukraine on the bar and legal practice. You believe that you are sufficiently competent, you have certificates, you improve your professional level in some other way. Moreover, you teach other attorneys, and that's why it is not mandatory to comply with requirements of the law? That's the statement. No, that's a question. Okay, that's a question. This question contains a statement which is not accurate. You are saying that I failed to fulfill with requirements of the association, and you equate those requirements of the association to the provisions of the law, but that's not the same. The law requires improvement of my qualification, and I do that. The Bar Association says, attend my events. Unfortunately, I don't attend them. But those are not the same notions. It does not mean that by not attending events of the Bar Association, I failed to improve my competence. On the contrary. A quote from Article 21 of the Law of Ukraine on the bar and legal practicing. While practicing law, the lawyer shall raise his or her professional level and fulfill decisions of self-governance bodies of the bar. And these bodies of the bar have adopted this regulation. Okay, let's move on to the next question. Do you pay contributions as the attorney? Yes. Yes. Have you received income from your legal practice during the period from 2021 until 2024? Yes or no? Let me look at my materials. Yes, of course. Otherwise, I will provide the answer for which later on I will have to be responsible. Okay, I found it. I'm ready. So, I've provided information upon request of the AGE in which I specified that I received income from my legal practice in 2022, in 2002, in 2010, in 2014, 2019, and 2020. For me, income from legal practice is not stable because I have full-time job, I have the employer, and this is my main occupation. The possibility to combine my academic and teaching activities with legal practice is set out by the current legislation. We all know about that. For me, participation in court cases is not a way to earn money. That is a way to improve my qualification and competence, and not as the attorney, but as the professor. Because I have the possibility to teach to my students not only from the textbook, not only theory, but also I can explain how this is all happening in practice. So, if you have a follow-up question or no, I will answer it. It is not strange that this income is not stable because I have other stable source of income. It is not strange that under some cases this income could not even exist due to different reasons. If you want to ask about that, please give me 3 more minutes and then I will explain. In order to explain, let's move on to a specific example. You've advised us on the criminal proceedings where you provide legal aid to persons. In particular, that is a proceeding with respect to citizen Olinek. Can you tell us, please, about the current stage of this criminal proceeding? This criminal proceeding is at the stage of... No. Preparatory stage is over. Now it's at the stage of hearing of the case on the merits, when the prosecutor shall read the bill of indictment. With the ruling of Kyiv District Court of Kharkiv as of November 3 of 2023, there was appointed court consideration of the criminal proceeding. So this case is at the trial stage. Based on which document do you provide legal aid to Olinek? In response to the previous question, I've already answered the same. This ruling shows that the stage of the preparatory hearing is over, and now I'm asking about the document based on which you are providing legal aid to citizen Olinek, based on order agreement. Yes, all of these documents have been provided to the AG. So, what is the document? Let me please explain. Yes, please. That is a certificate on the right to engage in legal practice. Firstly, secondly, order, and thirdly, the agreement on legal aid provision. All of these documents have been provided to the AGE. So now the case is at the stage of the trial hearing, and do you continue providing legal aid to citizen Olinek? Yes, yes. According to clause 1.3 of the agreement that you've provided, as you've emphasized, this agreement is dated August 16 of 2021. So in clause 1.3, we have a clear validity term of this agreement since the moment of its signing and until the end of the pretrial investigation under this proceeding. So based on which ground do you continue providing legal aid during the trial stage? This agreement has been prolonged, but now if now it is established that I do not have authorities for that, then why haven't you provided this document to the AGE if this agreement has been extended? The court and the client and the attorney will be very surprised. By the way, every time, in order to answer the questions, not every time, but in particular during the last 3 times, I was given, in my opinion, the term which was not satisfactory in order to provide the complete answer. I will explain now. Upon request dated June 29, I was given 4 calendar days, including 2 days offs. And the letter with your answers was received by me on Saturday at 9:35. I checked inbox at 9. No letters, no emails. Frankly speaking, I did not expect to receive an email from the AGE during the time off. I found this email on Sunday at 9 again when I checked my inbox. So out of 4 days, I had only 3 days remaining, including 2 days off. Then the next request, dated July 5. I was given, that was Friday. and I was given only Monday to answer the request. So in total, I had 4 days, including 2 days off, to provide the response. The fifth request dated July 7, and I had 2 working days to provide my answer. I believe that that was not completely enough in order to provide, in order to have the possibility to find all the documents, including the one that we are talking about right now. I have a client and I have the agreement according to which I'm providing legal aid. The agreement has been extended and I participate in this trial process based on legal grounds. Okay, clear. According to that agreement that you've provided to the AGE, after the end of the pre-trial investigation, the client had to pay to you by means of paying the respective honorarium. Has he done that? No. No. Now I have some questions about corporate rights in LLC law firm Utah. You've informed the AGE that you own 10% of the authorized capital stock of this LLC. The majority owner is another person. You've specified that 90% of shares are owned by another citizen. During the previous competition, in response to written questions of the AG, you repeatedly mentioned that approximately in 2005 to 2008, you stopped communicating with the other shareholder of this LLC, and since then, this company has not been performing any activities, has had no income, its own or leased property, hired employees, and it just existed formally on paper. Do you confirm this? Yes. Yes. At the same time, according to information from the Unified State Register of Court Decisions in 2009, this law firm Utah concluded a mortgage agreement, according to which there was put an encumbrance on its property. How did it happen that you state that there was no property, but now it turns out that there is property? Did you know about that? As I've explained, this company was established, if I'm not mistaken, in 1998 or 1999. After that, social economic interest which I had in this enterprise terminated. And as I've informed you previously, it happened approximately in 2005-2008. So information about the fact that, well, I know that the enterprise has not been liquidated, but I do not know about its activities. Okay, you don't know about it. Can you please tell us, since the moment of establishment of this company, you were the minority owner, or where was your share some different from 10%? You know answer to this question, as I've explained that in my written answers. If I'm not mistaken, and I don't want to take responsibility for the absence of documents, because I would like to emphasize again, if I'm not mistaken, then my share was 45%. Currently, you have 10%. Yes, 10% now. So how, where did you give this 35%? Let's assume that the remaining part is 35% as well, because 45% was an assumption as well. Why an assumption? Because all the documents, including minutes of the general meeting, charter, amendments to the charter, are held by the executive body of that enterprise, and that's not me. As you've explained, in 2005, 2008, since then you have not participated in the life of this enterprise, right? You did not take part in the general meeting of shareholders of this enterprise, did you? In my opinion, I've explained this completely in correspondence, and the situation is the following. I have 10%. The other shareholder has 90%. The current legislation sets out that the general meeting is duly authorized if 60% is present. So it means that the majority owner, who has 90%, is enough. No, my question was different. Did you take part? I'm not asking about the authorities of the majority owner. I'm sorry. Did you take part? No, I don't remember participating in that. I would like to emphasize again, for me, this enterprise stopped existing as the working entity. For me, it exists only on paper. To whom did you sell your share? Probably, if there are no other shareholders, then to the majority owner, yes. In response to the question that you have not asked yet, I would like to say that back then, this company did not have any assets, and that authorized capital of 28,000 hryvnias, which existed in 1998, it was not something untouchable. It could be spent. So, in response to the question as to how much I received for the sale of those shares, so 35% from zero, I got nothing. I was happy to get rid of this company. And for that, I cannot get rid of it without the decision of the other shareholder. But I did something else. I transferred corporate rights in order to put myself away from this company. Eduard, you've explained that you did not participate in the life of this enterprise after 2005-2008, and the general meeting was held by the majority owner. At the disposal of the AGE, not upon your initiative, but from the Ministry of Justice of Ukraine, we have received the minutes of the general meeting of shareholders dated December 6 of 2017. According to these minutes, you were the secretary at this meeting. You initiated consideration of some issues considered during the meeting with respect to which a decision was taken. It somehow does not correspond to your explanation that after 2005-2008 you did not take any part in the life of this company. Can you please phrase your question? Can you specify it? You are explaining that you did not take part in the life of the company after 2005-2008, approximately. The majority owner had the possibility to decide on all of the issues related to the company on his own. At the same time, at our disposal, upon the initiative of the Ministry of Justice of Ukraine, we have the minutes of the general meeting of shareholders dated December 6 of 2017, where you are specified as the secretary of this general meeting, initiator of some issues considered at the general meeting. So, why have you stated that you did not take part in the life of this company and that you were happy to get rid of this shareholder? It does not contradict my previous explanations. Can I look through the document that you have at your disposal? If it states that I take part in the life of the enterprise, it does not mean that I take part in the general meeting. Can you please look through that? Is that your signature? No. No. That's not your signature. No. Okay, clear. Okay. I don't have any other questions. Maybe other members of the AG have questions to candidate.
Запитань немає.
If there are no other questions, I have one question. Yes, please, Vasil. Can you please tell me what knowledge that you have received and what life experience can you use as the judge of the Constitutional Court of Ukraine? I'm convinced that right now I have a quite powerful set of knowledge that has been formed based on life experience over 55 years of my life, over more than 25 years of my academic and teaching activities, and approximately the same period of time, 25 years, of my experience as the attorney. I'm convinced that this set gives me opportunities to diligently fulfill authorities of the judge of the Constitutional Court.
Oleksandr Eduardovich, and finally, since you do not remember when you alienated your share in the we have the notary application from you where it specifies when, to whom, and which share, and how it is evaluated. The one that you allayed in the Utah LTD. Please give it to the candidate. If there are no other questions, Alexander Eduardovich, then we're giving you the chance to do your concluding remarks during 5 minutes. Okay, thank you. Dear experts, I would like the shade of unpleasant memories about our previous communication, which was not very successful for me. I want this time it all to be refuted by my clear and transparent and straightforward explanations. I tried to do everything possible to do this. Also have invested many efforts during the emailing with the advisory group. This is the independent competition, a separate competition. And I am convinced that even due to the negative assessment that I got, and it was stated that you think, in your opinion, I am not integral. But does it mean that me being convinced in the opposite thing, should I behave in a different way, not to be integral or to act not in the nice way? But I am convinced that I am integral, even despite the fact that last time I did not manage to convince you in your doubts, to dispel your doubts, because those are just doubts. I admit my mistakes. We have discussed them. They refer to the declarations and many other things. The mistakes are not signs of lack of integrity. The mistakes are made by all. Despite the previous decision, your decision, I will still act in the integral way, conscientiously, irrelevantly from the decision that is going to be made on the results of our today's interview. But I rely on your objective, unbiased decision, and as a minimum, for me, I wish to refine my name in the public space, because refining it for me, I do not have that need to do this. I need to do this in the public space, where everyone is using it somehow. Nobody knows whether or not the Verkhovna Rada chooses you, or you will be assigned by the meeting of the judges or others. Nobody may know this, because these are honest competitions. But everyone has the right to fight for their name. If I was not convinced that don't have lack of integrity, I wouldn't be brave enough to meet you for the second time. It seems to me that today I made a more successful attempt to convince you, but it's of course up to you. And I'm counting on this, on your decision. Thank you. Thank you, Oleksandr Eduardovich, for answering the questions that you were asked that refer to such components of integrity as honesty, as responsibility, in accordance with the methodology approved by the advisory group of experts. And also, of course, we are speaking about integrity. And now I announce the interview with the candidate for the position of the Constitutional Court of Ukraine concluded. Please leave the room and give us the chance to